Sports now. The murder trial of slain Bafana Bafana Captain Senzo Meyiwa will resume tomorrow morning. The trial started today from scratch. That's after the appointment of Judge Ratha Mokgoatlheng. He's taken over from Judge Tshifhiwa Maumela, who has been placed on suspension. The state may be funding the legal fees for the accused. Let's speak to legal expert Elton Hart, who joins me now to weigh in on what happened today. Thank you very much, Mr. Hart, for your time here on ENCA. Just firstly, this Judicial process that is now going to be discussed in the pre-trial conference. It's not a huge ask, right, by the defense to say, look, just because the trial is starting over, you cannot expect that our clients will pay us once again and we will bill them. The state should also take part of the invoice.
No, indeed so. But also what one needs to not miss is that while people are in custody, they don't have employment. So from that stance already, they qualify for legal assistance and a state-funded attorney. It's just now in this case, because we already have lawyers on record, it's just easier for them to expedite the trial, that they remain on record and then they do these applications to come on record as Judicial, and legal aid will then feed the bill, which is technically the taxpayer that's paying the bill. Because this unforeseen circumstance was not created by the defense team or the accused in this instance. It was a mere administrative thing that was between the President's office and the JSC. And obviously it will now negatively affect the accused. So hence, I think the judge was also very stern in saying that they would be allowed and they must do it within the afternoon so that tomorrow morning we can kickstart the trial.
Speaking of the judge, what do you make of the judge that presides over the trial now?
No, I think the judge that's now presiding, he was very stern in his opening remarks, how he wanted things, and you could see that he really wanted to get things on the road. For me, it looked like he wanted to start the trial today. So for him, postponing it till tomorrow shows that he doesn't have time to waste. And obviously, we know also there's a lot of time pressures on himself, because he's coming in at the very back end of what is already transpired on this case, with the 2 dockets, evidence already being laid. So there's extra pressure to actually expedite, streamline, and make sure logistical and administrative obstacles is eliminated from the get-go.
Tell me something, Mr. Hart. I wonder what you make of, of course, there's going to be a lot of things that have to start again. Like, for instance, the accused have to plead again. Their rights have to be read to them again, according to Section 35 of the CPA, etc. But today, they're still going to talk in this pre-trial conference about the indictment. Apparently, the accused, especially 1 and 2, are saying the indictment is different from the previous one. The charge sheet is different from the previous charge sheet. Can the state even do that in a situation like this one, change indictments and charges from what it was previously?
Now, obviously, there is an opportunity where the state can amend a charge sheet. You are allowed to amend the charge sheet in terms of Section 85 of the CPA, the Criminal Procedure Act. However, once they amend the charge sheet, then their rights need to be explained to them in terms of Section 35 of the Constitution, and they need to then replead on this amended charge sheet. And also the defense can also object if they feel like the client has pleaded and now there's now an amended charge sheet. They can also object to the amendment, and that's a whole application, which is an interlocutory proceeding that's going to happen before the judge, and then the judge can say, am I going to allow you to amend your charge sheet to now have certain elements in it? That's all but the state can do it, and then the defense can object, and then actually have an interlocutory application to say we oppose the amendment, and then the judge has to make a ruling on it. But it's not unheard of. It happened many a times that you can amend a charge sheet, and especially because of Friday's order that says whatever happened previously was declared a nullity, which means it is as if it never happened. It means that they've never pleaded. And obviously the state has the prerogative to stop prosecution at any stage, and then they can bring the people again to come and plead. So that's all in, but obviously you also have remedies for the accused at their disposal.
And of course, you heard the judge also emphasizing at some point, Mr. Hart, how the accused now have fresh right to apply for bail. He said, forget about what happened before.
Yes, the accused do have a right now to bring bail application, and even so, they can now say it's bail application on new facts, because they've been in custody for approximately 3 years. That's a new fact. So bail applications, normally your second bail application, if you bring it, if your first bail application was denied, you bring it on new facts, and a new fact would be the 3 years that they've been in custody. But because the proceedings, everything that was declared also a nullity, it gives it even a stronger feel to say that nothing has happened. So whatever the court decided previously can now be revisited. And obviously, they will not go to the same court. So the judge is going to preside over the trial will not be the judge that is going to hear the bail application. So the bail application will be heard by a judge in a different court, because the judge that's hearing the bail application cannot be the judge also hearing the trial. But they have this right now to go for a bail application, even if it's on new facts, because of the fact that they've been in custody and nothing has happened in 3 years in actually moving the trial, because it's starting now afresh.
So this trial, of course, has been scandalous from the beginning. There's also been applications within the trial, etc. But remember the different dockets, right, Mr. Hart? Are we going to possibly see this being discussed again, the defense trying to test whether the judge will come to a different conclusion in terms of the two different dockets? Or do we stick to what the National Director of Public Prosecution said in terms of this is what we're looking at and not the other docket?
No, the state has the prerogative to decide on which docket they proceed, and I think they will proceed. I think it's docket 363 that they are currently proceeding, because that's the accused persons in that docket. On the 375, it seems that there was also additional accused, and it was even the persons that they were the persons of interest was the people like that was in the house, like the Kelly Kumalos, Zandi Kumalos, the Twalas. All of them becomes people of interest in the second docket. So currently, these 5 accused are before court, and they say, okay, let's ventilate this issue. But for me, there lies a danger in that, because if those 5 persons that's currently before court get acquitted, and they charge the second 5 on the 375 docket, they can say, but we told you guys that that is the accused persons. So now there will be he shed, she shed, and then they will also be acquitted, and we'll never know what really happened in that house. So that is currently what those 2 dockets bring to us. But you can be sure evidence from both the dockets will be used in this first trial. So if a witness made a statement in 375, they can bring that statement because it was disclosed and use it in 636 as a form of evidence before court to test the witness on that. There's nothing stopping them from using that, because it's out in the open. The dockets is there, it exists, and it was disclosed.
Well, Mr. Hart, we're all waiting to see the first 4 witnesses of the state and whether or not, everything that they said in the first trial will actually corroborate when it restarts again tomorrow. It's going to be quite an interesting few months. Thank you so much for speaking to us here on ENCA. Legal expert Elton Hart, I'm sure you at home are also wondering if the stories we were told in court in the first trial will actually be the same stories. And remember, they have to take to the stand again, and the state cannot change that. They have to take oath again, and everything basically starts from scratch.